Hi, I'm Sarah Durham. I'm an associate attorney here at Blizzard & Zimmerman. My practice focuses primarily on direct criminal appeals and post-conviction writs of habeas corpus. In the past several videos, you've heard from Jacob about post-conviction writs, whether they be the 11.07 or a federal writ, and about kind of the requirements and the rules and, what to do and not to do surrounding those writs. Today, I want to talk to you more about what happens when you go to hire an attorney. You hire the attorney, and then what happens in that interim between the hiring and the filing of the application. Just kind of, unveil that mystery a little bit. What really is happening? What is the attorney doing for me? So at that initial consultation, before you hire the attorney, it should look like, just an information sharing session. So the attorney is going to come knowing as much as they can about the prospective client by doing just a little bit of research just on what, the client was convicted of, the offense convicted of, the sentence received, whether there was a direct appeal filed. If there was a direct appeal, has it been finalized? Has there been a writ of habeas corpus filed? And just those kinds of things. The attorney will know coming into the consultation. The family member or the friend comes to the consultation just ready to share the story and tell the story, the background, just what happened. What will the record not tell the attorney? What kind of went on behind the scenes. And then you will also tell the attorney, what you think went wrong. That's, the whole point of the conversation. Why do you think that, your loved one is in prison illegally, has been being held again, unconstitutionally so? And so after those conversations happen and it turns out that you want to hire the attorney and the attorney determines that there's a viable case worthy of pursuit, then comes the record gathering process. And that can take a little while simply because there's so many moving parts. The records are kind of spread far and wide. So the attorney will have to go to past counsels to gather those things. So the attorney will contact past defense counsel, the prosecutor, appellate counsel. And as you can imagine, sometimes it's difficult to get those files from the prosecutor. Sometimes the attorney general gets involved and it requires us to, the attorneys to kind of maneuver around those things. So record gathering can take a little while, but the records will be gathered. And really the methods that are used are phone calls and emails, letters even. We send letters requesting the records, online requests. Several police departments have open record request forms online. So there's just a kind of a myriad ways that we can accumulate those records. But then once the records are gathered, that's when the review starts. And the attorneys will review all of the transcripts and watch all of the videos. Maybe there's body cam video or security footage, whatever the case may be. Read the police reports, just whatever is available. Throughout that case, the attorney is going to review, all the while keeping an eye out for those issues that you've discussed or you've heard about from Jacob. So ineffective assistance of counsel, and then so many things can be tied to ineffective assistance of counsel, like Fourth Amendment violations, or perhaps a partial juror was sat on the jury that shouldn't have been there. Just those kinds of things. Due process violations. If it was a plea agreement, what was the plea agreement? Was it voluntary? Those kinds of things are constantly kind of in the background of the attorney's mind while he or she is reviewing those records. After the review of the records, and kind of actually at the same time, the writ application and the brief that supports it are being constructed. So the writ application is actually a form that can be downloaded from the Court of Criminal Appeals website, and that is where the facts are placed. So you have as many grounds as you can come up with. You can have 1 to 15 grounds. And in the writ application, you assert the ground and then the facts that support that ground. And then the second part of the application is a brief and support, and that is where the attorney, that's where more of the research comes in. And the attorney has to explain to the court, look, Court of Criminal Appeals, this is the law as applied to these facts that I've told you about. And this law says that when these facts happen this way, this client is entitled to relief, just tying all of that together. And so the brief and support and the application, along with any type of, documents or exhibits that need to be attached, are then filed as the application with the convicting court. And as you've learned in past videos, the convicting court has several things that it could do and must do, but eventually it will all be forwarded. The application and brief and exhibits and all will be forwarded to the Court of Criminal Appeals, and they are the ones who ultimately decide what happens in the case. So that is briefly kind of the life of the process from that initial consultation until the application. So I hope that shed a little bit of light on what is otherwise somewhat mysterious. And as always, if you have questions, please leave them in the comments and we will respond as quickly as we can. And thank you for watching. Y'all have a good day.